Hello, everyone, and welcome to the webcast. My name is Christine Dursey, and I'm the Executive Director of APA Ohio and Vice Chair of the Urbanism Division, and I'll be the moderator for today's webcast. Today, Friday, July 11th, we will be hearing the presentation, Current Perspectives on Inclusionary and Affordable Housing. For technical help during today's webcast, type your questions in the chat box found in the webcast toolbar to the right of your screen, or call the 1-800 number shown. For content questions related to the presentation, type those in the questions box, also located in the webinar toolbar to the right of your screen. We will answer those at the end of the presentation during the Q&A. On your screen is a list of the sponsoring chapters and divisions. I would like to thank all of those participating sponsors for making these webcasts possible. Today in particular, our webcast is sponsored by the Northern New England chapter. For more information on APA's chapters, visit planning.org/chapters. And to learn more about all the divisions, planning.org/divisions. On your screen is a list of upcoming webcasts. And for more information on these webcasts, visit utah-apa.org/webcasts. And to log your CM credits for attending today's webcast, visit planning.org/CM, go to your dashboard, select activities by provider, and don't select the APA Florida chapter. Please select the Northern New England chapter and select the title. I apologize. This webcast has been approved for 1.5 CM credits for live viewing only. Some recorded webcasts are available for distance education. For availability, check the webcast webpage again at utah-apa.org/webcasts. Of course, like us on Facebook, Planning Webcast Series to receive up-to-date information on upcoming sessions. And we are recording today's webcast, and it will be available on our YouTube channel. Just search Planning Webcast Series on YouTube. And a PDF of the PowerPoint will also be available at ohioplanning.org/webcast presentations. I'd now like to introduce our three speakers for today and then get the program started. Our first speaker is Chelsea McLean. Chelsea is an attorney in Holland & Knight's West Coast Land Use and Environment Practice Group and lecturer at the University of California Hastings College of Law, where she received her law degree. Her practice includes counseling clients on all aspects of regulatory compliance under federal and state environmental laws, with a particular concentration on the California Environmental Quality Act, the redevelopment elimination legislation, and climate change and green building laws, regulations and guidance documents, drafting and negotiating transactional agreements between developers, municipal agencies, and other third parties, representing clients in litigation arising out of the land use and environmental issues, and advocating for clients in the enactment and amendment of state and local land use statutes and regulations. Our second speaker today is Kevin Walsh. Kevin Walsh, Associate Director of the Fair Share Housing Center, joined FSHC following a clerkship in the New Jersey Supreme Court. Walsh, a graduate of the Catholic University of America and Rutgers University School of Law in Camden, is responsible for the Center's enforcement of the Mount Laurel Doctrine in high-growth municipalities and in municipalities with potential for transit-oriented development. He is also working on the Center's enforcement of civil rights and transparency laws as part of New Jersey's recovery from Hurricane Sandy. Walsh received the Mary Philbrook Award from Rutgers University School of Law, Camden, in October 2012, and was named Lawyer of the Year in December 2012 by the New Jersey Law Journal. Our third speaker today is Benjamin Frost. Benjamin Frost, AICP, is the Director of Public Affairs in New Hampshire Housing, where he coordinates federal and state legislative initiatives and provides direct technical assistance to municipalities to help them develop regulations promoting affordable housing and sustainable development. He frequently lectures on issues of affordable and workforce housing, planning and zoning law, and ethics. Ben has over 25 years of experience as a land use planner and 20 years as an attorney. Previously, he was a senior planner with the New Hampshire Office of Energy and Planning. He was executive director of the Upper Valley Lake Sonapee Regional Planning Commission, and he was also a planner and administrator in local and regional government in New Hampshire and elsewhere. Ben is a member of the Governing Council of Housing Action New Hampshire and a low-income housing advocacy organization. He is the past chairman of the municipal section of the New Hampshire Bar Association and is a founding director of the New Hampshire Municipal Lawyers Association. He represents New Hampshire Housing on the New Hampshire Energy Efficiency and Sustainable Energy Board. He serves as the treasurer of the New Hampshire Planners Association and is the professional development officer of the Northern New England chapter of the American Planning Association, and he coordinates the national consortium of APA chapters and divisions that provides these free training for professional planners. He is a member of the American Institute of Certified Planners. Ben is also a member of the legislative committees of the American Planning Association and the New Hampshire Bar Association. He serves on the Community Development Advisory Council of the Federal Reserve Bank of Boston. Ben holds a bachelor's and a master's in geography with a Soviet-Russian focus from Colgate University and Syracuse University, respectively, and a law degree from Cornell Law School with a concentration in business law and regulation. He lives in Warren, New Hampshire, where he serves on the planning board. Without further ado, we are going to turn it over to Chelsea. And I apologize, this might take a moment. We have a lot of folks on our call today, and our system is a little low. Here we go.
Okay, hello everyone. Good morning to the West Coasters and good afternoon to the East Coasters. Christine, thank you for that introduction and thank you for organizing this event. As Christine mentioned, I'm a California land use attorney at Holland & Knight, and I advise developers throughout the entitlement process on compliance with the myriad of California land use and environmental regulations. As a bit of further introduction, I do come from a family of city planners, so I hope that gives me an extra badge of credibility in this crowd. So jumping into the content here, we're going to cover a whole range of affordable housing issues. In California, many cities have imposed inclusionary housing requirements. That is, ordinances that require a given share of new construction to be affordable to people of low to moderate incomes. I am going to ruin the suspense here and go ahead and give up a few of the most important takeaways from my presentation. First, and most importantly, the California Supreme Court is currently reviewing the appropriate standard of review for affordable housing ordinances in a case called California Building Industry Association versus City of San Jose. Out of that Supreme Court decision, which is fully briefed and is expected to be heard by the Supreme Court sometime this year, I think we can safely expect heightened scrutiny for exactions, including monetary exactions and exactions for permanent denials. And so in the context of affordable housing obligations, again, I think we can expect heightened scrutiny when courts are looking at those types of affordable housing ordinances. So as a result, cities are responding by preparing detailed nexus studies to demonstrate the link between new market rate development impacts and the need for affordable housing. Another issue we will discuss is that the imposition of affordable housing obligations on rental development is unclear because of a separate line of cases and actions. So with that, I'll go ahead and dive into a bit of the historical background in California. Many cities and counties have adopted inclusionary ordinances as a means to provide low-cost housing. The first ordinances were adopted in the 1970s, gained prevalence in the 1980s, and increased in the 2000s. There have essentially been two types of inclusionary housing requirements, either set-aside requirements, which require a certain number, typically 15% of new units, to be available to people of low to moderate incomes, or number two, in lieu fees that a city can use to build affordable housing units elsewhere. Developers have challenged these ordinances for years as presenting a number of legal issues. And on the other hand, affordable housing advocates argue that the need for affordable housing has grown dire given the elimination of redevelopment funding, and I might also add the astronomical cost of housing in California. So this historical tension has more recently been compounded by new and more recent pressures. So we have tensions between developers looking to ensure that obligations accurately reflect actual residential impacts, affordable housing advocates concerned about housing affordability, and municipalities looking to achieve affordable housing targets. Some of the new pressures come from new legislation. In 2008, the legislature passed SB 375, which mandates more coordinated jobs, housing, and transportation planning. Notably, it put pressure on cities to meet housing targets. Then, in 2011, Governor Brown eliminated redevelopment agencies, which provided a major source of affordable housing subsidies using tax increment financing. This funding source has not been replaced. So to put the affordability crisis into perspective, this slide reflects the booming real estate market in the Bay Area and San Francisco in particular. If you can't see the coloring here, the yellow line indicates that the median home price in San Francisco, which admittedly is a very wacky real estate market, but the median home price is $900,000. And I personally can speak from experience as I've been trying to buy a house with my husband for over a year and a half within and outside of San Francisco, and we are consistently outbid. Another interesting anecdote I think that illustrates the affordability crisis is what we call the Google bus wars. So shuttles for technology companies like Google and Facebook pick up employees in San Francisco and bring them down to the Silicon Valley. Those buses have been blockaded, egged, protested, everything under the sun. And so many people feel that the working class, the teachers, the artists, those in public service are being pushed out of San Francisco due to the affordable housing crisis. And in the midst of this affordability crisis, a series of disjointed legal opinions has resulted in a patchwork of inconsistent rules related to affordable housing. So this multitude of questions and inconsistencies between different courts throughout the state has resulted in the type of storm that often prompts the Supreme Court's review, as has occurred where the California Supreme Court granted review in the CBIA, California Building Industry Association versus City of San Jose case on September 11th, 2013. So there's a lot to be gained if the court provides guidance on some or all of the questions I will note below. The ordinance at question in the California Supreme Court case is an ordinance adopted by the City of San Jose. The San Jose Ordinance required developers of for-sale residential units to set aside 15% of their project units as affordable. In the alternative, developers could satisfy the obligation in three ways. Number one, they could build inclusionary units off-site. Number two, they could pay an in lieu fee for the city to fund affordable housing units elsewhere. Or number three, they could dedicate land suitable for construction of units elsewhere in the city, and that land value would have to be equal to the value of the in lieu fee. The question presented regarding the San Jose Ordinance is whether it is appropriate, and a consortium of builders brought a suit to challenge that ordinance. And again, the question is, what standard of review applies to this type of inclusionary housing ordinance? And a standard of review is essentially a legal term for the type of test that the ordinance has to pass in order to be upheld. the courts have identified 3 possible tests, starting with the highest level of scrutiny that would give the city the least amount of deference is the Nollan-Dolan standard of review, otherwise known as the Nexus rough proportionality test. The second option is the reasonable relationship test, and the third option that would give the agencies the most amount of deference is the police power test. I'll talk about each of these tests in a little more detail. The first test, again, the one that has the highest level of scrutiny, and I'm sure that most of the planners here are familiar with, is the Nollan-Dolan test. The Nollan test requires an agency to demonstrate a nexus, that is a legitimate state interest in advancing an exaction. And the Dolan test requires an agency to demonstrate rough proportionality between the magnitude of the exaction and the nature and extent of the project impact. As a bit of a sidebar here, the Nollan-Dolan test could be imposed on the San Jose Ordinance based on a recent U.S. Supreme Court decision in Koontz versus St. John's Water River Management District. So in the Koontz case, the developer sought permits to develop a section of his property from the St. John's River Water Management District. The district rejected the proposal only if the developer decided that he would reduce the size of the development and deed to the district a conservation easement on the property, resulting in a larger remainder of the property, or if the developer would hire contractors to make improvements to the district-owned property several miles away. So the Supreme Court reaffirmed the Nollan-Dolan test here and so that it applies to a denial of a permit and monetary exactions. So the takeaway here and the applicability to the San Jose case is that this U.S. Supreme Court case was a reminder of the high standard of review that applies to exactions. Another sidebar here is that the Nollan-Dolan test could also be imposed based on the California Mitigation Fee Act. I won't go into all of the components of the act that I've listed here in the slide, but again, the takeaway is that the California Mitigation Fee Act could be applied to the court's consideration of the San Jose Ordinance and require this, again, this heightened standard of review such that the city would have to really demonstrate the link between the impacts of market rate development and the requirement for affordable housing. Moving on to the second test, it is the reasonable relationship test, and that requires, as it sounds, a reasonable relationship between an impact and an exaction. The trial court, so the lowest court in the San Jose case, held that the San Jose Ordinance could not meet this standard and thereby held that the ordinance was invalid. If the Supreme Court selected this test, it could invalidate inclusionary ordinances throughout the state, at least temporarily. The third option is the police power test. The police power test is highly deferential standard of review. Under this standard, the ordinance would be considered invalid only if it's arbitrary, discriminatory, and without a reasonable relationship to any legitimate public interest. This deferential police power standard would allow cities to adopt and defend similar ordinances under most any circumstance. So now that we've considered the 3 options for the standard of review, the question is, what are the prospects for the San Jose Ordinance? So we have a couple of signs and indicators here. The first is that the Supreme Court has granted review of the 6th District's opinion, and that's a sign, of course, that the Supreme Court will select a standard different than the lenient police power test used by the appellate court. The second sign is that the U.S. Supreme Court reinforced the Dolan standard of review and the Koontz decision. Number 3, the California Supreme Court recently held in yet another case, Sterling Park versus City of Palo Alto, that the longer statute of limitations in the Mitigation Fee Act applied to a developer's challenge to an inclusionary housing obligation. And again, that just indicates a willingness of the Supreme Court to apply more of the Mitigation Fee Act's heightened scrutiny to other inclusionary housing obligations. So given all these signs and indicators, it appears that the Supreme Court has now established a trend of moving towards a higher standard of review. So if I were to wager, I would bet that San Jose's ordinance will be set aside because the city didn't have anything in the record to establish nexus between the market rate housing impacts and the need for affordable housing. They adopted the ordinance. Again, there was nothing in the record. There was no study to support that nexus. So as a result, and while we wait for the Supreme Court's decision, which of course can take 1 to 2 years, many cities have started to prepare and have adopted detailed housing nexus studies to quantify this linkage. Studies associated with the nexus studies include development fee comparisons, where a city will compare its development fees to those in neighboring cities. They will also prepare a fee burden analysis where they will look at hypothetical development, say a 100-unit multifamily project. They'll also consider something much larger and consider how affordable housing impact fees would affect those hypothetical developments. They are also looking at asking rent analysis to determine the asking rent in any given city. And then they're also looking at how the rents compare to average worker compensation. Now these nexus studies are hundreds of pages long, but can be simplified into a few steps. The first is that the nexus study will look at the newly constructed market rate unit and how they represent new households. The second step is that the households represent new income that will consume goods and services in the city. Next, new consumption translates to often low-income jobs. And lastly, low-income jobs translate to lower-income households that need affordable housing. So again, these are very long studies prepared by very qualified and equipped economic and planning consultants, and it all boils down to this step in logic to link the market rate housing to the need for affordable housing. This slide here shows the range of affordable housing fees in the Bay Area. The fees range, as you can see in this middle column, from $10,000 to $50,000 per market rate unit. So particularly when we're talking about San Francisco, these fees are really quite substantial, and as the developers will tell you, often make it difficult to have a feasible, economically feasible project that pencils. This column here shows the range in set-aside requirements, which ranges from 10% to 20%. San Francisco is actually considering increasing that set-aside requirement to 30%. So again, quite substantial here, and helps indicate why this is such a hot issue in California. So because we can always count on more litigation in California, the next round of litigation may be on these nexus studies. So developers, opponents may question the methodology in the nexus studies. They may ask whether the data is accurate and supported. Who knows what other challenges they may bring. In my view, California courts are likely to uphold these several hundred-page nexus studies. Once a city has done the work, hired the consultants, done the detailed analysis, again, my view is that a city is not going to question that, and that they are going to give deference to the agency's review and adoption of those types of Nexus studies supporting affordable housing fees and set-aside requirements. So in conclusion, cities with affordable housing ordinances on the books or proposed for future would be well advised to consider preparing Nexus studies similar to the ones that are being prepared in California. So finally, I'm going to just briefly touch on a couple of other affordable housing questions that are not squarely in front of the Supreme Court, but that warrant some additional clarification. Again, just briefly, another question that is sort of swirling in California is, and actually just nationally as a result of the Koontz decision, is whether conditions imposed on an ad hoc basis, that is on a specific development project or permit, continue to be subject to a higher standard of review than legislatively imposed requirements, so those imposed via a generally applicable ordinance. And the rationale is that for ad hoc conditions, there's a greater potential for abuse when conditions are imposed on that single project versus citywide. And interestingly, in the Koontz decision, they did not emphasize that previously very well-established distinction. The dissent noted maybe today's majority accepts that distinction, or then again, maybe not. At the least, the majority's refusal to say more about the scope of its new rule casts a cloud on every decision by every local agency to require a person seeking a permit to pay or spend money. So again, more uncertainty regarding the standard of review as it applies to both ad hoc and legislatively adopted conditions. And then the last question that we're thinking hard about here in California is how affordable housing obligations apply to rental housing. We've talked in the past about these affordable housing ordinances that apply to for sale developments, and there is a separate question as a result of a decision in 2009, Palmer versus City of Los Angeles, which held that Los Angeles's inclusionary housing ordinance violated state law found in the Costa-Hawkins Act. Now that's a real estate law that dealt with landlord-tenant rules and said that a landlord always gets to determine the initial rental rate, and that therefore that state law preempted any local city law that tried to regulate rental housing. So it was this very odd and unexpected kind of overlap between real estate law and land use law. Very unexpected, and as a result, though, cities could not impose affordable housing obligations on rental development. Last year, the legislature tried to fix this. They adopted legislation AB 1229 that would have superseded the Palmer decision, but interestingly, our Governor Brown vetoed that legislation and basically said that as a mayor of Oakland in his prior career, he saw how hard it was to bring new development into the city, and he wasn't convinced that affordable housing ordinances were effective. Despite Palmer and AB 1229, cities continue to impose affordable housing fees on rental housing, but again, they're using these Nexus studies as the justification to do so. So with all that background in mind and all of these legal questions that are swirling, the stakes are really high. And so we are really hoping that when the Supreme Court makes a decision, that it will provide guidance on a lot of these questions. And a lot of parties could benefit from that. Cities and affordable housing advocates could receive guidance to ensure their obligations will stand on solid legal ground, and developers may gain comfort the affordable housing obligations will accurately reflect the actual impact of their residential development. So in the meantime, again, we expect heightened scrutiny for exactions, including monetary exactions and exactions for permit denials, and Nexus studies as the justification for those obligations. And lastly, until the Palmer decision addresses rental housing, imposition of affordable housing fees on rental housing is unclear. So with that, I hope that some of the Challenges and lessons learned in California are useful to planners and practitioners throughout the country, and I am going to turn it over to Kevin for the New Jersey experience.
Hi everyone, Kevin Walsh here from Fair Share Housing Center in New Jersey. Going to tell everybody about our experience in New Jersey over the last several decades with the Mount Laurel Doctrine. We're a group of primarily lawyers here, but we have community organizers and we contract with planners to do the work we do, which is enforcing the obligation in New Jersey for all towns to provide their fair share of the regional need for affordable housing. Our organization was founded in 1975, following up on the original Mount Laurel decision, and it was founded by some of the attorneys and plaintiffs that were involved in that original case, which I think a lot of planners out there probably studied in school. For the past 40 or so years, our organization, in collaboration with other civil rights groups and with developers and other nonprofit organizations and very often religious groups, both statewide and in specific municipalities, have advocated for the enforcement of affordable housing obligations here. And I'm going to tell you a little bit about that work, which is important work, we think, because New Jersey is so profoundly racially and economically segregated, and that really results in a lot of the opportunities in the state being distributed in ways that deny lots of people opportunities for no reason other than the zip code they live in. The effort that started here in New Jersey began back in May 1970 when a local group of largely African American residents there, former sharecroppers, as the story goes, who were gathered in a church that was part of the Underground Railroad to hear the mayor, Bill Haynes of Mount Laurel, tell them what he thought and what the people in charge thought in the town of their proposal to build a modest development of garden apartments at a time that Mount Laurel was itself approving huge developments that wouldn't have been affordable to the people who were living in the town. Mount Laurel has an exit on the New Jersey Turnpike, and at the time there was a lot of deteriorating housing that wasn't up to code, and rather than helping take any steps or rather than encouraging the landlords or requiring the landlords to do anything, Mount Laurel's approach was just to condemn the housing after people moved out. And at the same time, it was occurring at a time of tremendous white flight out of Camden, just 10 miles away, in a state where people were only beginning to come to terms with deterioration in places like Camden and the separation that white flight caused. When the mayor showed up and said, as it says here, if you people can't afford to live in our town, you'll just have to leave, it was the sort of thing that really offended the people who were gathered there, who had worked and lived beside the people who were in power, and didn't expect them to use the zoning power to in effect force them out of town that they'd lived in for a long, long time. It was that effort that led to the Supreme Court's decision in 1975, and again in 1993, which I'm showing you an important quote here from. That decision stood for really three things. One is, as it says here, the power to zone is one portion of the police power and must be exercised for the general welfare. The court said, second, that the general welfare includes more than the welfare of that municipality and its citizens. It also includes the housing needs of those residing outside the municipality but within the region. And then third, that regulations that municipalities adopted do not provide the opportunity for a fair share of the region's need, conflict with the general welfare, and violate state constitutional requirements. So with that reasoning, from a legal standpoint, the court found in 1975 and again in 1983 that municipalities throughout the state have an obligation to provide their fair share of the regional need for affordable housing, and that in effect, their municipal zoning ordinances are unconstitutional if they don't meet that obligation. As you might expect, that was a decision that was both celebrated and rejected by lots of folks as not what zoning is intended to be. But it was really, I think, driven, and as the court recognized in those decisions, really driven by the understanding that the power to zone was being used in ways that was promoting racial and economic segregation in New Jersey and unfairly leaving some folks to stay in cities where they were forced to deal with declining tax bases and forced to deal with the impacts of racial segregation. And that historical context at the time very much influenced the courts. The courts provided a remedy in 1983 that they didn't provide initially in 1975 when they first decided that all municipalities have fair share obligations. And what the court did in 1983 was incentivize the private sector to bring what's called builder's remedy litigation, where as long as the proposed zoning is consistent with sound comprehensive planning, the developer, if it proves that the municipality has not met its fair share obligations, that developer can receive a change in zoning so that the municipality cannot any longer stand in the way of developing what in most instances would be 20% affordable housing without any public subsidies at all. About 100 municipalities were sued soon after that decision was reached. And as a result, the municipalities were incentivized to push for legislation in which the state legislature in 1986 adopted the Fair Housing Act, actually in 1985, and the Council on Affordable Housing went into effect in 1986, and it assigns municipal fair share obligations, thus avoiding, I think, many of the sorts of studies that Chelsea discussed to the state's 565 municipalities, both for new households and for households living in substandard housing. Based on census data, it comes up with both the need for housing and the number of substandard units in each municipality. Municipalities are required under the law to come up with strategies to both provide a realistic opportunity for the new construction obligation and to put together programs that can help landlords and homeowners bring their homes up to code. It's been pretty successful in part because for 12 years up until 1999 things were going well, and there are about 90,000 homes required to be zoned for throughout the state to meet the needs of new households whose needs otherwise wouldn't be met through other ways of providing housing affordable to lower income households. It creates an administrative process, and so municipalities really like that because they were no longer being sued in court and they felt like they could somewhat control their destiny. And the success rate we think is pretty good. It is an effort that has resulted in about 60,000 homes for families, seniors, and people with special needs. And even among those seniors and people with special needs are still preferred in some ways by municipalities, because the only thing in many New Jersey suburbs that's worse than a school child is a lower income school child. But Mount Laurel has done a good job of checking that exclusionary impulse that too many municipalities here have. We've, as a result of a law passed in 2008, there used to be a requirement where municipalities, usually wealthier municipalities, could pay poorer, racially segregated municipalities to accept their up to half of their affordable housing obligation, and that law was abolished. That practice was abolished, and at the same time, a law was put in place that requires 20% affordable housing in state-designated transit-oriented transit villages, 20% affordable housing in developments that are either on state land or receive state funding, such as brownfields. And then there's several regional planning areas here, the Pinelands, the Meadowlands, the Highlands, where 20% of new housing is required to be affordable as well. Resulted in tremendous increase in municipalities that would otherwise keep out even non-affordable but middle-class owners and renters, there has been, along with the affordable housing and inclusionary developments, significant development of housing that's affordable to people who might not be lower income but are just barely not. We reached down to 30% of median income in New Jersey, which I think is, without any form of public subsidy, probably close to the best, if not the best, rate of affordability for purposes of providing opportunities in high opportunity suburban municipalities that otherwise would be denied. And compared to many other places, I think including California, the for-profit sector here has actually been incentivized to provide affordable housing. It's in many ways, I think, the price of admission here. I don't think the developers are necessarily looking to do it, but they realize that it may be the only way that they can develop. And while they still might try to shake the obligation at the end of the day, it's been the primary way that we've developed affordable housing, almost always without any form of public subsidy. The impact has really been tremendous. We know on families that have been eligible to take advantage of the affordable housing that's been built by Mount Laurel. It has resulted in, and this is, you see here, the cover of a book called Climbing Mount Laurel by a sociologist at Princeton University called, by the name of Doug Massey. He and his team of researchers did this study over the past several years. It came out in 2013 and has been won multiple awards. And the reason is because I think that is a well-documented example, sociological study of the impact of housing on people. And this is a development called at the Lawrence Homes in Mount Laurel itself, some way connected to the original rejection of that mayor. And decades later it was realized, it's been around for a little over 10 years, built with federal low-income housing tax credits and substantial subsidies, gets down to 10% of median income, has social services and an education component on site. And really, although I don't address it here, the book, which has been covered by the New York Times and other outlets, shows that so many of the fears, they went through the planning board transcript when neighbors came in, and shows that so many of the fears of people were just that, fears and not reality. And I'd urge you, if you're ever coming up against NIMBY folks, to take a look at this, and I think it'll give you some basis to tell people that their fears are probably unjustified. It shows really positive impacts for adults, reducing exposure to disorder and violence, having improved mental health, increased economic independence. And one of the suggestions was, well, if lower income folks move from Camden nearby to Mount Laurel, they're going to lose their social network, and that was shown not to be the case. For adults, one of the things that came out of this that is really important, a really important anecdote, was a woman who had lived in Camden, high poverty, high crime area that is not a place where, unfortunately, employers are very often going to look in the region or go to look for employees. This woman was a paralegal, by all indications accomplished in what she did, and worthy of an interview, but when her address said Camden on it, she couldn't get, on her resume, she didn't get any calls. She moved to Mount Laurel, and she started to get interviews, and that is really unfortunate and nothing to be encouraged, but it shows the reality of how some people think and why it's important, I think, for people to be given these opportunities. The results on children, I think, are most exciting, and one of the things that keeps us going and doing this work. Shows improved learning conditions at home, more studying. Kids, of course, are going to better schools, and the exposure to disorder and violence was also reduced within schools. It also showed that while the kids' grades may not have substantially increased, they didn't go down. Given some of the schools where they were coming from, where there was lower levels of achievement, that was an accomplishment. This shows you what the development looks like in Mount Laurel. And one of the things we're really proud of, and although that development is unique with its affordability range and the provision of social services, it really shows at the same time how it is that checking exclusionary zoning in really direct ways can help lower income families with the opportunities they have. The next thing I'm going to discuss is now sort of showing you what we've succeeded in, what the history has been, and I'm going to discuss briefly how the Mount Laurel Doctrine has been, perhaps because of its effectiveness, some may say in the past decade or so, the subject of pretty substantial political resistance and the manner in which that was done. And Mount Laurel has always been enforced with a fair share approach. And about a decade or so ago, the state of New Jersey started to promote something called growth share, which was a direct linkage between municipal decisions and to grow with regard to residential growth and with non-residential growth. And there was formulas established, ratios established by which municipalities would, in effect, determine their own affordable housing obligations by determining whether or not to grow. This has been rejected in court decisions repeatedly in 2007, again in much the same form in 2010, and then most recently by the New Jersey Supreme Court in a September 2013 decision. And the reason throughout the cases, and going back to Mount Laurel II, is that the Mount Laurel Doctrine is not simply about creating affordable housing opportunities. It is also about creating affordable housing opportunities in ways that check exclusionary zoning, in which municipalities aren't allowed to use their zoning powers for ulterior purposes, which is to keep out working folks. One of the lines from Mount Laurel II is, if we're going to have factories, we have to have places for workers. And as the Supreme Court said in Mount Laurel II, municipal population projections are based on many factors, but in no case that we know of do they include a value judgment that such municipality should bear its fair share of the region's lower income housing need. And the court goes on, in effect, to say that municipalities too often can't be trusted to meet regional needs, so we're not going to base growth projections or the actual fair share obligations on what municipalities think is right, because they're too often planning for their own politically popular needs, not planning for the actual needs of the region. And when you have 565, two towns just recently merged, 565 municipalities in New Jersey, it's sort of a race to the bottom. The New Jersey Supreme Court in its 2013 decision accepted that, and just a note to your national organization and to the New Jersey chapter, the APA, which argued that the growth share approach is unconstitutional because it doesn't ensure that municipalities will be required to meet the regional need. In effect, allows zoning to be used to keep people out. And thanks to the APA for that, and other groups that joined in that were special needs providers for people with disabilities, civil rights groups, religious groups, even a couple of municipalities that thought that they had done their fair share and they were right, and they said that that other municipalities, if they don't do their fair share, that will be detrimental to municipalities that have done their fair share, and it's not fair when municipalities can use their powers in ways that disadvantage others like that. The ACLU also joined on, and the September 2013 decision of the New Jersey Supreme Court directs the State Council on Affordable Housing to go back to the system that worked previously. They were originally supposed to be adopted in March of this year, but the Supreme Court gave them more time until November 2013. While the court somewhat suggested that it's open to changes, the legislature thus far has not gone along with that. The Christie administration and the legislature here in New Jersey don't see eye to eye on that. It used to be that the judiciary was the one that was holding the line on this, and while it still is, the public opinion on this and the politicians in the legislature also recognize that housing that folks can afford is a legitimate issue that is not any longer quite as politically toxic to discuss. It's now a positive, as the state legislature has in recent years either rejected really bad things that the Christie administration has proposed or actually passed good legislation that got signed into law that improved affordable housing opportunities throughout the state. The court, as you see at the bottom of the screen there, the court affirmed that it is going to continue to enforce the constitutional obligation and will not allow the general welfare to be harmed by proposals to change the way in which the Mount Laurel Doctrine is implemented. But we still have our challenges, and those challenges remind us every day that as I'm sure all of you on the phone know, planning decisions and housing decisions are fundamentally still political decisions, and the fight for this never ends. One of our big challenges is this man, who has made it his Governor Christie. If he's not in your neighborhood now, he will be someday soon, going around the country raising money. One of the big things that he's attempted to do is undermine fair housing laws in New Jersey, even though he makes it his point to talk about how he's helping working class folks. In fact, that has not happened through foreclosure policies and his continuous veto of laws intended to help people facing foreclosure, and through his effort to allow municipalities to exclude by using zoning as red tape. He has made it his priority to undermine Mount Laurel. Thankfully, the legislature and the judiciary have continuously pushed back in his efforts to do so. The business community as well, not just home builders, but also folks that want to see our economy strong, have also rejected his efforts to put in place a law that emphasizes home rule over regional responsibilities. And the fight continues, though. The governor just recently pushed through some proposed rules to comply with the Supreme Court's September 2013 decision that have so many problems that we have asked the New Jersey Supreme Court to intervene. We've now been about 15 years without strong, consistent, reliable, and legal law rules in place, and if the governor has his way, that will go on for another 15 years because he is doing everything he can to undermine Mount Laurel. Another challenge that we have is that the state agency, which was a place where planners primarily worked to help municipalities come into compliance, to evaluate their compliance, to mediate disputes, has been largely dismantled. The governor has even removed the words Council on Affordable Housing from their nice brochure that they hand out, and taken their what they do and turned. You see there, I pulled out that one thing that ensuring that municipalities meet their affordable housing obligations is now one of 24 things that they're required to do, and so they're not doing a very good job on it anymore. And that's one of the reasons why we've asked the Supreme Court to allow local courts to take back over the process of ensuring municipalities meet their affordable housing obligations, because at the end of the day, even if this agency came up with good rules, it can't be trusted to make decisions that are neutral. Rather, everything is happening now with looking over your shoulder about which politician you might upset. We're also, though, facing opportunities, and that's what I think often keeps us going in this. The opportunities include a legislature that supports Mount Laurel. We have the basic legal requirements that every municipality must provide its fair share of the regional need for affordable housing. The private sector, as mentioned, supports the check on exclusionary zoning, supports efforts to curb abuses through home rule. And one of the other exciting things organizationally we're working on is that federal law requires efforts to promote racial integration. It's something that that has too often gone unrecognized, and it's something here in New Jersey with our recovery from Hurricane Sandy, with $5 to $6 billion in funding that has some of which already been spent, most of which hasn't, requires that municipalities in the state look at these local zoning decisions and other similar processes by which we say where housing can go and where it can't, and plan for that in ways that don't exacerbate the divide and try to close it. So that concludes my work. If you're interested in hearing about our organization, there's our website. You can also get information through the text, and if you do it in the next 3 seconds, you can also scan that with your phone. I am now going to hand this over to Ben. Thank you for listening, and I welcome your questions at the end.
Thanks, Kevin. As we're making this transition to my screen, I think you can see it now. I just want to thank Chelsea and Kevin for being on today's webcast. I saw them in a presentation at the National Planning Conference in Atlanta this year, and asked them after that was over if they'd be willing and interested to do this webcast, and they both eagerly agreed, and here we are. So thanks to you both. I think it's really important for for everyone, especially planners who are in smaller jurisdictions like New Hampshire, to pay attention to what's going on in the heavy hitters like California, generally because of its massive economy and robust judicial structure, and also places like New Jersey with its really strong history of affordable housing litigation. Because places like New Hampshire don't have the same robustness of case law, our courts, in particular the Supreme Court, tends to look outside of our jurisdiction to see what's going on elsewhere for some guidance, and that has certainly happened here. What I want to do is to conclude these presentations with kind of a small state perspective, the view from New Hampshire on inclusionary and affordable housing. And just to orient you, New Hampshire, there we are. We're the second northeasternmost state in the country, little, but big in comparison in terms of our first in the nation presidential primary. And of course, I think everyone knows our state motto, live free or die. And it's more than just a joke, although it does get regular play on the Daily Show. It actually is a reflection of the political ethos of the state. We had a governor in the 70s named Mel Thompson, a three-term governor who was, well, infamous in some circles for inviting Martha's Vineyard and Nantucket to secede from Massachusetts so they could annex to New Hampshire to enjoy our tax benefits. But Mel Thompson also was known to have made a citizen's arrest of someone who had covered over the state's motto on his license plate. People take this really seriously, and this is reflected in, well, first off, New Hampshire is, although it's not a home rule state, we're a Dillon's rule state, meaning that municipalities have to find a grant of authority from the legislature to do anything. People believe it's a home rule state, so there's a really strong history of local control. But sometimes the state does step in, either acting through the legislature or through our courts. And that has happened in the law of affordable housing in New Hampshire. Britton versus Chester is our Mount Laurel II. It was decided in 1991 after like 5 or 6 years of litigation. The trial court in this case looked at the town zoning ordinance, and this was brought by a number of different people, one of whom was a builder in town, the town of Chester, which is a small bedroom community outside of the city of Manchester, which is our largest community at 110,000, but Chester is only a couple thousand people. It's really a crossroads rural town, and people would commute to Manchester or Nashua or even the greater Boston metro area for work. And a local builder who wanted to build some affordable housing on his property found that he couldn't do it because of the zoning ordinance. A couple other parties to the litigation were someone who was a renter in town, couldn't afford to buy, and someone who lived in a different town and couldn't afford to move into Chester. The case was litigated by New Hampshire Legal Assistance, which is our statewide nonprofit low-income law firm. And New Hampshire Housing, my employer, acted in kind of an expert role in support of that litigation way back when. But the town zoning ordinance, when the court looked at it and did some mathematical calculations, determined that after you eliminate wetlands and steep slopes, only 1.73% of the town surface area was suitable for multifamily housing, and the court said, frankly, that's not enough. The trial court threw out the entirety of the town zoning ordinance on constitutional grounds. This got appealed, and the Supreme Court, we don't have an intermediate appellate court in New Hampshire, so it's a direct appeal to the Supreme Court. The New Hampshire Supreme Court backed away from that constitutional cliff and instead turned to our zoning enabling statute, which is really based on the standard State Zoning Enabling Act that was promulgated by the U.S. Department of Commerce in the 20s. And so you'll see similar language in our Zoning Enabling Act as you find in many other states, including language that says that the purpose of zoning is for the public health, safety, and welfare of the community. Well, central to this case was the court's interpretation of what the word community means. And it means not just the municipality itself, but the region within which the municipality is situated, its neighborhood, really. And the court said municipalities are not isolated enclaves, and they actually put this into the opinion. They can't dig moats around themselves and pull up the drawbridge. And then in this case, the New Hampshire Supreme Court looked at Mount Laurel II and said, well, that's very interesting. And we understand that, you know, the New Jersey Supreme Court has taken this approach of effectively imposing mathematical calculations on municipalities, but we're not going to do that. In fact, the court said that they eschew that sort of imposition. Rather, they left it very vague. And so the central holding of this case is that every municipality in the state has an obligation to provide a reasonable and realistic opportunity for the development of housing that is affordable to low and moderate income families. And also that every community has an obligation to provide for its fair share of the region's need, and that's where the question of the word community comes in, the region's need for affordable housing. The builder's remedy was awarded here. Well, then what happened? 1991, many of you may remember what the housing market was like nationally. The late 90s, that recession was really New Hampshire's Great Recession. That's when the housing values in the state really tanked. The past recession, we got hit hard like many others did, but not quite so hard as we had in this recession. Well, then what happened? Not much. Except that the remaining 233 municipalities in the state effectively wiped their brows and said, thank God we're not Chester. Well, Chester did proceed and amended its zoning ordinance, and the builder ultimately got to build on his property, economy notwithstanding. But not much else happened with regard to other municipalities responding to this case law. But there are a couple other decisions. I did not provide a citation to this case because it's not published. If you're interested in seeing the court's order in Great Bridge Properties, just email me and I'll be happy to send it to you. This is simply a trial case that was not appealed, and we have a for-profit builder here, Great Bridge Properties, that wanted to build some affordable housing. AICP, again, is a kind of a bedroom community. And the developer was faced with these limitations based on the zoning ordinance and sought variances. Multifamily was allowed, but you could only build it on water and sewer and only in existing buildings. And only one principal building was allowed on a lot, which precludes multi-building developments, and a maximum of 4 units per building. So you do the math, and you can figure out pretty easily that affordable housing is not going to happen. Well, the star of this case, of the variance hearings, was the chairman himself. And I put this in really for entertainment value. This is probably far worse than what the mayor of Mount Laurel said to that group gathered, because this was on the record. And the ZBA chairman said, when this ordinance was written, it was known at the time that it was exclusionary. It was written exactly for that reason. So not only, he's saying, does our ordinance have a discriminatory impact, it has a discriminatory purpose. That was its intention. So you can put yourself in the position of being the developer's, the applicant's lawyer at that hearing. This was probably the best day of his life. So what happened? Yes, it got built, and that's what they look like. Builder's remedy was not awarded here. Rather, the court said, you got to go back to the planning board. We'll give you the variances, but you got to go back to the planning board, where by all accounts, the applicant was treated actually pretty well. Through the years since our Mount Laurel, Britton versus Chester in 1991, the New Hampshire legislature, looking at the impact of high housing costs on our state's economy and the inability of people to afford housing, not just lower income people, but moderate income people as well, middle income, the middle class. The New Hampshire legislature studied this over and over and over again, and finally in 2008 adopted the New Hampshire Workforce Housing Law. And it has this language in it that harkens back to Britton versus Chester and harkens back to Mount Laurel II. Reasonable and realistic opportunities, including multifamily rental. But in particular, the New Hampshire Workforce Housing Statute, like the Supreme Court decision here, does not contain mathematical calculations. It's very broad and very general, and imposes a kind of a hortative obligation on municipalities to figure out what they're supposed to do to meet this general obligation. But there are a couple of things that really stand out. One is that they have to look at the collective impact of all land use regulations. So zoning, subdivision, site plan regulations, impact fees, all of those have to be piled together, and then the planning board has to assess what the impact is on a developer's ability to profitably build affordable housing. A couple of definitions here, and I was thinking as Kevin was speaking about the depth of targeting in New Jersey. 30% is really low and deep targeting, and that's wonderful. Our statute is based at 60% of median income, which is pretty good targeting, but it certainly could go more deeper than that. And when you look at the definitions of what workforce housing is, that is the income targeting, and then combine that with the definition of what affordable is, which is the 30% benchmark, you actually can come up with a price point for both rental units and for ownership units. And again, we revisit fair share, no statutory numerical standard. It simply says that municipalities must provide for their fair share, and it's up to them to figure out what that means. This has not been litigated since the law was adopted in 2008, but I expect that it will be at some point. Appeals, we have an accelerated appeal mechanism within our workforce housing law so that a developer who is proposing a workforce housing development, and this has to be in writing as part of the application. You can't spring it upon the planning board halfway through the process. The developer can challenge either a denial or unreasonable conditions of an approval and can get a hearing on the merits in 6 months. There have been a couple of cases tried under the workforce housing law, and it's been a mix of decisions, some denials of the developer's claims and some approvals of the developer's claims. But generally speaking, I think the courts have done a pretty good job, both in meeting this time deadline and also understanding what the statute means. Planning boards themselves can impose affordability restrictions, and I think this is really essential for people to understand how they work and where they should be required. But the court can also impose them if the planning board has not. There's been a lot of reaction, to the workforce housing law. Not all of it pleasant. But generally speaking, the communities that have had to respond, those where development is actually occurring, have taken a fairly proactive approach. Now, turning to inclusionary zoning, in New Hampshire, and this I think is distinguished from a number of other jurisdictions, inclusionary zoning in New Hampshire can only be voluntary. That is, a municipality cannot require a developer to build an inclusionary development, but can only offer incentives to a developer to do so. And that the admonition I have here is that don't inadvertently create barriers with unrealistic requirements. Actually have to look to see what will work in the marketplace if you're serious about pursuing inclusionary zoning. And we have a model that was created by our State Department of Environmental Services. So in inclusionary zoning, incentives and restrictions, what can the developer get? Well, primarily it's density bonuses, but also look at other dimensional standards, lot sizes, frontage in particular. Well, less popularity, I'd say, is financial assistance. You know, municipalities tend to be fairly tight-fisted. Also, reduced fees and phasing. Certainly, limiting the phasing requirements and limiting growth management requirements is important to help reduce costs by increasing the speed with which a development can be built out. Now, what should the municipality get? Well, assurance of long-term affordability. This is, I think, the critical factor, because where a municipality is voluntarily giving say, a density bonus, it should be getting something in return, not just the affordable housing, but also the assurance that that housing will stay affordable over the long run. And this is actually an example from that model guidebook that our State Environmental Services Department created. And what I say, these are merely suggestions, and the point is follow the money. What will actually, in a voluntary inclusionary setup, what will induce a developer actually to want to do this. It has to be profitable for the developer. Also, in standards, well, make sure that the styles of the affordable units are similar, or I'd say even, if possible, indistinguishable from those of the market rate units. Mix the affordable units in amongst the market rate units. Don't ghettoize them. And where you're phasing, don't, and this is important from a municipal perspective, don't allow all of the market rate units to be built before the affordable ones, because what happens if the developer goes belly up after building all the market rate units? You're left with strictly a market rate development. And now I have a couple of examples. This actually is the Britton versus Chester development. It was built about 12 years after the court decision. It's actually a really good conservation subdivision that has built on 23 acres but 19 acres in conservation. You can see the density bonus. It was a 25% density bonus for income targeting. And these are for sale townhouses. And I just checked some of the prices of them this morning, and they're selling at around $225,000, which for that particular market in Chester, which is relatively high income, it gets to about 80% AMI. In Exeter, New Hampshire, this is a terrific mixed-use infill development that unfortunately required, I think, 6 variances to get it built, but the ZBA wanted it, the planning board wanted it, the board of selectmen wanted it, everyone wanted it to happen, and so it happened because the developer was motivated. But this replaced a surface parking lot. This is mixed income and mixed use. There's ground floor retail, and they replaced the surface parking with an integrated parking structure that tripled the number of parking spaces. It's a pretty cool development. One thing I really would encourage is that people look at their zoning ordinances to make sure that older structures can be converted to multifamily where it's appropriate. This example is in Hopkinton, New Hampshire. It's an old farmhouse that was converted into 4 or 5 units, and it's virtually impossible to tell that it's multifamily from the street, except if you're counting the electrical meters. But this only happened because the town zoning ordinance allowed for it to happen. There's no subsidy here. This is just a market rate development. On the bottom, Bellamy Mill, that is a low-income housing tax credit development, a former textile mill that was converted by a developer in 2004. Again, because this is the city of Dover, the city's zoning ordinance allowed for it to happen. I am really bullish on accessory apartments. I think it is a terrific way for people to accommodate not only a changing population, but also the decreasing size of families and the need for older homeowners to get some extra income. So this accessory apartment was built over a garage, and it's otherwise impossible to tell, except for the fact that I've drawn the box around it. And how do I know it was there? Well, I used to live there. Multifamily development, this again is a tax credit development in Amherst, New Hampshire. And Amherst is distinguished as one of the most affluent communities in the state. It's very high income, very high land costs. Yet in the 1980s, even before our seminal affordable housing case, Britton versus Chester, the planning board in Amherst decided that they didn't like what was happening with the housing costs, and they can't change the market, but they can change their zoning ordinance and allow for affordable housing development. So Amherst, still one of the most affluent communities in the state, has been for almost 3 decades now a leader in affordable housing development by simply allowing it to happen. And this was done in the town's historic district, so it winds up looking really pretty spectacular. I'm going to skip over Exeter in the interest of time, and I'll wind up with this list of resources here, which I'll leave up for a couple of seconds. And if you have any questions, there's my email address. And now, Chris, I will turn it back to you.
Great, thank you. Okay, let's just jump into some questions for the last few remaining minutes that we have. All right, the first question is for Chelsea. Are developers being asked to contribute to Nexus studies, or can the fees be used for such studies?
Sure, thank you for that question. As far as I know, the developers are not being asked to contribute to studies. The cities and, one thing I kind of wanted to qualify, as I heard Kevin and Ben's great presentations, is that the experience I've talked about is not completely uniform. I'm speaking mostly for the Greater Bay Area experience, and these are largely progressive cities that are looking to bring in more affordable housing units. It's not necessarily the statewide experience. Marin County, for example, is one area where there's been some resistance to affordable housing, and other jurisdictions have faced some of the, or they've demonstrated some of the same resistance. And so it is these progressive cities that are looking to bring in affordable housing units. And so for my experience, it is the cities who fund these Nexus studies, and I'm sure they are not cheap, but knowing that they will legally support the ultimate affordable housing ordinances that will then bring in lieu fees from developers, I think that's how cities justify the cost of the studies.
Okay, well, stay there. One more question for you.
Okay.
I think it's for you. Under Palmer, is there a limit to rental time frame? That is, can a lease be 99 years to avoid fees?
Can a lease be? Interesting question. Thinking through that, I would imagine that a lease of 99 years would be subject to the same restrictions as under the Palmer decision, but haven't seen that question addressed squarely.
Okay. Well, you keep thinking about it, and feel free to interrupt
Sure.
if you think any further about that.
Okay.
Next question is Kevin. How does zoning alone in New Jersey result in affordable housing without subsidy?
Most often it's done through a density increase, and there's a minimum required density depending on certain factors that such as rental units get a higher density, and for sale units have to occur a density of at least 6 units per acre, and then there's sometimes sort of negotiation or an objection process to get the density level up. But it generally works by developers coming in and optioning land and then trying to get it, very often rezoned in a builder's remedy context, or municipalities go out and plan and propose to landowners that their land be rezoned. It is a process that has the Builders Association here wishing that they could go back to the good old days of density increases, even with the municipality being able to pick and choose which sites without a builder's remedy, without the developer having much leverage, because they would be able to do a much better job in their view of meeting the market demands. And it just works out in ways that when they can develop at a high enough density, it may come out of the land cost, but at the right density, they can produce 15 and 20% rental and sales set-asides all day long in almost any market in the state. The downturn has had some impact on that, but we still see even in many places, even 20% in some rental contexts, 20% affordable housing being developed.
Great. Let's talk a little bit more about density bonuses. There's a couple questions coming in asking what density bonuses have been found to be an effective incentive, particularly with the voluntary.
Well, this is Ben. I can start with that. Kevin, you want to go?
Yeah, here in New Jersey, it's usually not voluntary. It's just a mandatory set aside at this density. If you're going to develop this site residentially, this is the density. It's mandatory. You've gotten your density increase. Go forth and prosper. That's how it most often occurs. There are not voluntary components.
Yeah, in New Hampshire, as I said in a presentation, we have a voluntary inclusionary zoning only. That is, the statute does not allow for mandatory inclusionary zoning. Density bonuses are pretty all over the place, and I think what counterbalances the density bonus is the affordability requirements. So, for example, if and this is where I was careful to caution about making sure something actually works in the marketplace. You may provide for a 25% density bonus, but if in fact your affordability requirements even meet or even exceed that, it's going to become cost prohibitive for a developer to build. So there has to be kind of a market testing, which means that if you're developing these sorts of standards, you've got to talk to developers and figure out what will work for them under hypothetical circumstances within a community.
Great. Can you, and I think maybe this is Ben, can you explain the builder's remedy in more detail?
Can, but I think Kevin would be better suited for that.
Okay, so that was Kevin's. Okay.
Yeah, so in New Jersey, the way the builder's remedy works is a municipality that has not met its affordable housing obligations and does not have a protection from either court, which can issue protective orders, or the Council on Affordable Housing, can be sued by a developer for a rezoning in which the developer first has to prove, and this is very often easy to do, that the municipality has not met its fair share of the regional need for affordable housing. And then the developer has to show that the proposed rezoning is not bad planning, and that the density, and that's often where the arguments occur, what is the density, that the density is appropriate and for the site, and then the developer usually provides either 15% rental or 20% sales of affordable housing. And the cases very, very often settle because it is very clear that the municipality hasn't met its obligation, and the developer may have some room to come down in what the developer might ultimately get from the court. And so these cases settle. Sometimes they don't. Sometimes, towns, one of the sayings that a mayor came up with here is that it's cheaper to litigate than it is to educate. And so very often the towns do not settle, but most often they do.
Great. This is an interesting question. How are HOA fees typically handled in affordability calculations?
I can answer that in New Jersey. It used to be that the people in the affordable units paid less, and it led to a lot of problems. So now they pay more, and it's just adjusted in other ways with, maybe the unit might sell for less, or, but generally now people in developments built, I think in the last decade or so, pay the same rates as others. And it leads to some problems here sometimes, because sometimes the affordable units, don't have the exact same layout, or they don't have a driveway with a garage, and so there's still sometimes where things, you need some sort of mediation, and there's still occasionally problems, but overall, by getting people to pay the same rate, it's addressed the thorniest of problems.
In New Hampshire, under our workforce housing statute, that there is no accounting for homeowners association fees. So you might have caught on one of my slides the affordability calculation for workforce housing for owners is principal, interest, taxes, and insurance, and they pay, that should not account for more than 30% of their income. So I think that actually is a flaw in our statute, because a lot of the affordable ownership housing in New Hampshire is condominiums, and people are paying these fees, and sometimes they are the property unaffordable.
All right, great. We'll take one more question and then we'll wrap up. I guess kind of going along with the workforce housing statute, Ben, can you discuss the process to get the state to adopt a workforce housing statute?
That would take a lot more than a minute, 30 seconds. It was actually, the story is interesting, and it included the partnership between the low-income housing advocates, such as New Hampshire Housing and New Hampshire Legal Assistance, with our state's Business Industry Association, which is our statewide chamber of commerce. And that partnership proved to be very, very strong, so that we were then able to negotiate with the New Hampshire Municipal Association, which then, and when we had a meeting of the minds, our groups essentially all went together to the legislature and said, we have a solution to this problem. But that took years to develop.
Chelsea, do you want to, thank you, Ben. Chelsea, do you want to wrap up your a response to your previous question?
Yeah, just going back to the original question for me about whether under Palmer there's a limit to rental time frame, whether a lease would be extended 99 years to avoid affordable housing fees. I do not think there is any restriction. You know, it is what it is. If a development is being proposed as rental, that's what it is, and the Palmer decision would not be subject to fees. But one point I wanted to mention in sort of a trend for the future, the market has been so hot with rental in the last few years, and I've sensed, if it hasn't already happened, will happen very shortly, the conversion to condos. And so I think that is going to be an issue to watch out for, that as owners of these multifamily projects want to convert from rental to condo ownership projects, arguably then fees will be applicable at that point. So again, I think that's an issue to look out for and to be aware of.
Great. All right. I think that's going to wrap us up for the day. So Chelsea McLean, Kevin Walsh, and Ben Frost, thank you for speaking today, and for the Northern New England chapter for hosting this event. Thank you. And everyone have a really great weekend. And if you have any questions, the contact information, hopefully you've been able to take it down, or you can always email us. Have a great weekend, everybody. Thank you.
Thank you.
Thanks, everyone.
Thanks.